what I find very disturbing in the contempt for the law that we find coming increasingly from the state. I think everyone who went to Parliament in 1994, like for me, for example, went there, and I think we should have all said the most important thing is fixing the injustices and the disposition of the past. I don't see a lot of that. And I see incompetence. Look at the price, I think, 1.7 billion rand, and we've got a train that doesn't even work. And has the minister been sacked? No. Who did they choose? The civil servants. And I think until we face up to the fact that as citizens, if our government, whether it's municipal, whether it's national, whether it's provincial, while they steal and while they misuse money for get-rich-quick purposes, somebody has to be held accountable, and our courts should be doing that. Whether we need to have let's hope Tony Madonsela goes to court and gets a ruling on her powers, and we do with a couple of her, but nothing. I don't feel things are getting better. 35 billion rand was missing last year, and the same for the last 20 years. That's 700 billion rand. That could fix a hell of a lot of wrongs.
From the point that Alex made, and we couldn't understand because we don't have the legal training. Who holds government to account?
Yeah.
Because we as citizens believe we should hold government to account. On the many issues, we've had many examples. For example, an order requiring the government to open up the refugee centres that are closed. A court order requesting or requiring Bashir to be held in the country. And we had many other examples in our group. But as the ordinary citizen, we ask the question, well, who is supposed to hold government accountable? If I murdered someone and I was taken to court and I was sentenced, Mashuka said, well, the police will take you down to the cells and take you to Westville. So that I can understand. So when government breaks the law or is not accountable, and who follows that up for the citizen? Yeah, that's our question. Yeah. I don't understand. I'd like to know.
Thank you very much. It's been a very interesting discussion. I really enjoyed the contributions of these two gentlemen. I listened to historians just a couple of weeks ago in Grahamstown paint the very same picture that there's this coercion which has a history of 100 years, apartheid-style coercion that is now creeping back into our country, and that is what we are witnessing. But, you know, it's not about what has happened then, it's what is happening now that matters to us. And from day to day, we hear the cries of ordinary people, workers, citizens, unemployed, regarding this inequality that they suffer from, we suffer from on a daily basis. But former judge has raised a very pertinent point, which is indication, direction to the sections of the Constitution which are supposed to guarantee equality, freedom, fairness. But then the question is, how much have we achieved? We certainly have not achieved what we had outlined in the Constitution should be achieved. How much longer are we to wait? If a class action is brought to the courts and brought before the Constitutional Court, which says, let us repair all the wrongs that were done in a scale which is preached by the likes of the EFF, etc. Land restitution and that kind of thing on a large scale. With the Constitutional Court, really, can one expect the Constitutional Court to change things? You know, And one, one just has a sense that we could be another 100 years from now, and we could be sitting and talking around the table these very same things. Nothing would have changed for the ordinary person. Thank you.
Thank you. Thank you very much for our speakers, because we thoroughly enjoyed the discussion. We also shared a view of the other speaker concerning the sanctions or the consequences of government not obeying the ruling. That interests us to a large extent, and I hope that's going to be covered seriously by the speakers. Something else that we want to say, we spoke about, is the perception that the public has, and that is that the judiciary leans towards government, especially in some of the way things or orders are granted and rules are applied, judgments are given. And things like parole, those sorts of things. There seems to be lack of consistency in the way that it's applied. Also, the fact that judges are appointed by government in terms of the Judicial Services Committee also has fuels that perception that we have. So these are some of the things that we'd like to see this to address.
We felt that the rule of law was always in change. We came from a heavy, krachtdadig kind of system where all aspects of our lives was covered by one rule or another. That's why it was called petty apartheid. Got petty, got to a point of would you love. We inherited a system of, heavy rules-based administration. But the concept of justice came in with the new constitution, and it seems to be a stumbling block in the path of persons who are trying to resolve some Peter Blanche's accumulation crisis that he raises. So it seems that there's an intention to squeeze the judiciary into a corner, get them out of the way, so that there's a freedom to implement an agenda which seems to be around accumulation.
Okay, interesting point.
The age of the President al-Bashir. So my question is like this. Which law supersede between the AU laws as well as the laws of the ICC? Because on the issue of al-Bashir, my understanding is that President al-Bashir was here in South Africa not on a normal visit as a president, but on an invitation by the African Union. So I think there are laws that govern the African Unions, also the laws that govern the International Criminal Courts. Which one is supersede the other?
We found that we were shortchanged on a comment on the judiciary itself. In the sense that we believe that the judiciary that we have plenty of it's in a fragmented state on its own. So before we can look at the political system and so on, we can look at firstly the judiciary. Does it really carry or does it really emulate the aspiration of communities? By means of transformation, we talk about race representation, we talk about issues of gender in the judiciary, we talk about issues of disability and so on. So for the institution to be taken seriously, it has to emulate the aspiration of communities. Second to that is the Constitution. The gentleman talked about issues of compliance and so on. I believe compliance comes with a sense of ownership. If you own something, then you comply to something. I do not know the process how the Constitution was formulated, but I hope to be educated as to how it was formulated. But was there an engagement with the people on the ground in terms of understanding their aspirations? Or did we basically have a sample of individuals who are politicians who decided this is the direction of the country, and that was imposed onto the masses for implementation and so on? And that, I would like to stem that in the current system that we have of policy formulations and policy enactment in our country, which is a failure because we find that it's only a sample of individuals that are consulted and a policy is formulated and it's adopted, but it does not represent the general consensus, consensus of the lessons. So I'd like to educate on the second part, largely, and the judiciary and issues of transformation. And our judiciary currently is reduced to only a commission, a final commission, and so on and so on.
According to what the judge has given in terms in terms of the statistics that is given of unemployment, what is happening and so on, I don't think all of those that have mentioned, the 24 million statistics, those things are in line with the principles of constitution, in line especially in terms of the social justice, not justice, social justice. Also, the preamble will talk about the spirit of improving the life of the people. I don't think that's happening also. It is a line of improving. So isn't that the judiciary has got a responsibility? Because what is happening there is not in line with the constitution. But the irony here is that the judiciary is waiting for the initiative. Now the judge has put it clearly that anyone who's poor, who hasn't got anything, is going to be surprised. What is the active role of the judiciary except that it must be an initiator who brings the matter before them? Thank you.
Maybe the question would be, do we all actually understand the Constitution, how it's applied or implied or functions? And maybe the other comment that I'll have would be like, is our Constitution friendly? Or is it an easy document to read and understand? Because in most cases, whatever we see on TV or here in radios, we rush to use our emotion to judge because we don't understand actually how we're supposed to be responding to the problem that is actually occurring. I think maybe that's what it is.
What can the people do about inefficiency, incompetence, etc.? Now, that's a very good question. And what one has to do is look again at the Constitution. The Constitution is the foundational document of the whole country. It provides for how Parliament operates, how laws are made. Everything in the country is governed to some extent by some provision in the Constitution. It provides the framework, the skeleton. And then laws are made by Parliament that have to comply with the Constitution. And for the sort of problems people have been raising, there are a number of remedies. If it's a criminal act, in other words, if it involves an assault, murder, rape, theft, fraud, then the criminal courts are available to any aggrieved citizen against any other citizen. If it's not a criminal offence, if you have a contract with the government, in other words, if it's not something that's criminal, but you have a grievance, you can go to the civil courts. So the civil courts provide a remedy to the citizen for matters involving breaches of contract. An example is if the police van crashes with your car, that's a civil action. You sue the police, you sue the Minister of Police for damages arising to your car because of the collision with the police van. If the police rape your daughter, you raise a criminal case. You bring a case of rape in the criminal courts. There's a further remedy available, and that is all government servants are governed by disciplinary codes. And you can lay complaints, and what should occur is those government servants should be dragged before a disciplinary code and charged with the infraction or the breach of the particular code. And although they might get it deferred or postponed, in the end, hopefully, an inquiry will be held and some independent person will sit on that disciplinary committee and decide if the person has been negligent or intentional and apply a sanction, which could be a warning, it could be a deduction of pay, or finally it could be, of course, dismissal. So those are the first three remedies. The problem is that there are some matters that don't fall under any of those categories. And the answer to quite a lot of your questions is going to disappoint you all, because the only answer is vote them out. You see? You have to go garnish enough support and say this government is corrupt, this government is inefficient. We vote them out. So apart from the criminal remedy, the civil remedy, the disciplinary remedy, there are then the political remedy, and that is go garner support and vote them out. The trouble in a country like South Africa is the government is so strong that they can often get away with what they ought not to get away with. In Britain, I mean, a cabinet minister can do something like Profumo or anything in the old days, and the government will fall very quickly. If the competing parties in the state are of equivalent power, the governing party is much more well behaved, because they know that anything serious they do, they can be voted out. So the trouble with us at the moment is there isn't that countervailing opposition. Hopefully with time there will be, because my view is that the government will be put on their toes and they will try and look after the voters, which will involve looking after the poor. And they will carry out their duties, not only to the poor, but to society in general, on the basis of what's provided within the Constitution. Now, various other questions were asked about, well, listening to your cell phone in the car. Well, that's bad, but it's not as bad as some other things that are going on. I think you'll all appreciate. If billions are missing, then there should be prosecutions for fraud or theft.
Yeah.
And sometimes one gets the impression, and there are lots of hungry lawyers out there who could be used to bring these prosecutions. One sometimes gets the impression in this country that if you shoplift and you take a bar of soap, you get dragged before the courts. But if you take 35 billion or 35 million, it becomes so complicated, or the machinations of so many are involved, that it never goes to court. And in the end, if it does go to court, none of the right people are taken to court. So, you know, the Bashir matter is maybe quite a complicated case at a legal level. But in the end, there's a hierarchy of norms in society, and our domestic law. The domestic law is the law that applies via our Constitution. And what Ebrahim was talking about, the Rome Statute, included in our domestic law the creation of the International Court of Justice. And so, rascals and rogues from wherever they are in the world, if George Bush arrives here one day, in theory, you could arrest him and drag him before the International Court sitting in Durban for his illegal invasion of Iraq. It's a brave man that will do that, but the mechanism is available. So, with Bashir, there is an AU dimension to it all. He was clearly a guest of the AU, but what the judge decided, and I think there will be further proceedings, was that our domestic law trumped the AU conventions. In other words, any alleged immunity he was given when visiting South Africa did not avail him in terms of our own laws. If there was a justifiable complaint, then Bashir must be arrested and then a trial must take place. So it will be very interesting to see what happens there. Of course, Bashir is no longer here, but it may be that somebody gave an order that he was to be allowed free passage to Waterkloof or wherever it was, and waved off by a Batman and out of the country. Now, if you can find the people involved, they are, in theory, guilty of contempt of court. They are in contempt of a court order. But you have to first show they knew about it and then deliberately frustrated the court order. And that's why I think it will be a touchstone of our whole system, because it's a very important case. And we'll have to see what happens there.
Thanks, Chris. Ebrahim?
Thanks, Rama. You've basically given us 10 seconds for each question.
Okay, so you worked it out, that's
Look, I don't want to waste time, but I want to put this idea to rest. I'm not saying that there is an equivalence between a small infraction and a large infraction. So let's just put that to rest. I'm simply trying to illustrate the point. The question of the rule and the supremacy of the rule of law, particularly based on justice, is all of our responsibility. But it's the smaller acts which start leading up to the bigger ones. There's a reason why I pointed to the impunity of the private sector. It's simply because they're the ones who get away with doing everything. The small guy doesn't. But there are three things which struck me from all of the comments and questions which arose, and I'm going to cluster my comments around these three. The first is the question of greater coercion and, as it's been called in Afrikaans, kragdadigheid. And I presume what that is pointing to is the force of law and the way in which control is attempted to be kept. Now, if you really consider it, South Africa, notwithstanding high levels of crime, the creeping intolerance politically in our institutions and so forth, is in fact quite a liberal society. There's almost unfettered religious freedom. There's almost unfettered freedom of speech. There are few places in the world in which you get away with nakedly calling the president a crook. That's just it. The consequences are going to in fact be minimal, if nothing. I regularly do this in public. We have a remarkable jurisprudence around the rights of sexual minorities and all kinds of other liberties. So we are in fact quite a liberal, free society. We're not a kragdadig society. But you have to get into our heads, all of us as society, that the rule of law based on justice is not about the idea of kragdadigheid and control. It's about ensuring that all of us play within a particular set of rules. The problem at the moment is not the question of kragdadigheid, it's the question that some of us are playing outside of the set of rules. So the converse is the problem. There's a few of us who are playing outside of those rules, while the rest of us have to play within them. Which brings me to the second broad thing. What's the difference between law and politics? Well, the one is about attempting to capture power, and the other one conversely tries to limit it. That's the difference. The one tries to capture it, and the one tries to limit it. And our problem, to come back to the second claim I was making when I was standing up there, is we have a president and a governing party which is exceptional at the way in which they are able to capture and legitimate political power. On the other extreme, it appears that they are completely woeful in the way in which they instrumentalize the use of that power. It's one thing to be able to capture power. It's one thing for me to have a sophisticated device like this. It's quite another to be able to use this efficiently and effectively. Yeah. Now, it's understandable. We literally, and I'm going to emphasize this again, have a history of 20 years in which we're attempting to govern a modern society with a complex economy based on the idea of the rule of law, factoring in the question of justice. On the way here from the airport, I was saying to the person who kindly drove me here that in Europe it took them more than a century to be able to entrench some of the norms that we now take for granted as the result of the Enlightenment. The Enlightenment was more than a century after people were marauding and burning each other's houses down and splitting each other's skulls. But literally, the short difference between law and politics, the one captures it, the other one tries to limit its use. And the limit of the use of power is a good thing. We don't want anyone in the society to have unfettered and uncontrolled power and authority, which is what the current president appears to want to do. And I often remark that the work that started under Thabo Mbeki, undermining institutions, meddling in institutions, meddling in the business of the alliance facade with the Communist Party, that work is being completed by Thabo Mbeki. The unions have never been as decimated as they are now. The economy has never grown in such a slow and sluggish place as they are now. The level of public ethics in the way in which decisions are made have never been at such a low ebb post-1994. So he's completed the work that started under Thabo Mbeki. All of this erosion of institutional autonomy, hollowing out of the public service, meddling in the business of alliance partners. You know, it certainly didn't start under Jacob Zuma. It started under Thabo Mbeki, but certainly this guy is finishing the job and doing so very well by all accounts. Yes. The third and very important one, which I wanted to actually touch on, is, you know, you guys want to place an onus of responsibility on a document this size. I mean, look at your size compared to this thing. You want this small document to solve all your problems. But the judge has already said you don't like certain things. You've got remedies, you've got recourse. He's pointed out three very important ones, and I can simply underline the final one. You don't like how a government's behaving. Vote them out of power. But let's also not lose sight of the fact that South Africans do hold the government to account. It might not always necessarily be through the ballot box. And people who voting repeated the ANC are not irrational. There's something fundamentally rational about why they're doing so. In part, the ANC is in fact delivering to them. In part, they see themselves reflected in the ANC. But in part, they hold the ANC to account by either staying away from the polls or taking to the streets. I mean, we have close to 500 protests around the country a year. And often, frequently, those are about holding a local power holder to account. But while that may be true, let us not and let us resist the temptation to say that the judiciary remains untransformed. Far be it from me to emphasize the point, Deputy Chief Justice Museneke has basically said, don't question the credibility of the judiciary and its transformation credentials. It is appointed through an extensive process through the Judicial Services Commission, in which all political parties, those political parties represent you, like it or not. They sit there, they make decisions about who's appointed as judges. The legal profession is represented on the Judicial Services Commission. It is a multi-stakeholder structure with literally everyone's interests taken in. If you look at the transformation of the judiciary, we've never had as many black South Africans and women represented in the judiciary. So this idea that the judiciary does not reflect the demographics of the country is a red herring, and it's a red herring which we should fish out the sea and burn once and for all. It doesn't, it's not true, it's an unsustainable contention, and it's not a claim worth giving a lot of attention to. It is also not true to say that the ethics of the judiciary are not reflected in the society as a whole. They are. This very document is an aspiration of what the society wishes to be. That you don't like what this is, you must organize politically and then vote yourself into power to the extent of 75% and then change the constitution. There is no one yet in the country which has been able to show how the constitution constrains more rapid socio-economic development and equality. Because we keep hearing, oh no, the constitution is a constraint on land reform. The constitution is a constraint on, or you know, the private property rights entrenched are constraint on delivery. How? No one can. I mean, even my former boss, Braden Zimandi, cannot actually demonstrate how the constitution constrains more rapid delivery. So the idea that we can question the Constitution, I think, is a red herring. Finally, the Constitution was as widely consulted, and it's not an elite document. If you look back at the Transitional Executive Council and the processes which followed after that, In 1994, we went to an election. Everyone is able to vote. There was no voters' roll. I mean, even people who weren't citizens in the country were voting. Those people then became a constituent assembly. But the constituent assembly had a very large support staff. And that support staff's job was to do what was done at the time of the drawing up of the Freedom Charter. Those people literally solicited ideas from ordinary South Africans about what they want to see in the Constitution. There was a toll-free line. You could write a piece of thing on a matchbox and post it off. You didn't even have to pay postage before someone says, but that was a barrier to entry for poor people. That was paid for by the Constituent Assembly. So literally, anyone was able to make submissions. The Constituent Assembly ended up with close to about 20,000 submissions from South Africans across the board, including professional associations and other NGOs, whatever, including ordinary citizens. That was synthesized to come up with this. Obviously, there were a few elite advisors who drew this thing up. I mean, that's natural. But to say that the Constitution is an elite document is another red herring. And I'm running out of fishing rods, so I'm not going to fish it.